Good evening, everyone. I'm C. Amita Vissa, moderator of this webinar. We are delighted to welcome you all to the webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be the moderator for the webinar on Introduction to POSH Act 2013 and Professional Opportunities for Chartered Accountants, as held today on 21st August 2025, uh, being organized by the Committee on Commercial Law, Economic Advisory and NPO Cooperatives of ICAI. In a short while, we will begin this webinar. I would like to apprise you about the CCLEA and NPO committee. This committee is focused on encouraging chartered accountants to shape strategies and policies that unlocks economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, development and publication of technical guidance, background material, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisories, and NPOs cooperatives. At the outset, we take a moment to respectfully acknowledge the invaluable leadership of CA Abhay Chhajir, Chairman, CCLE, NEC, and CA Pramod Jain, Vice Chairman, in absentia. Uh, though they are unable to join the seminar of today, their unwavering support and guidance have been instrumental in shaping this initiative. We extend our deepest gratitude for their vision and commitment for the professional excellence. We are honored to have with us today CA Nitika Sood, a distinguished chartered accountant with over 18 years of professional experience. She holds multiple credentials, including FCA, DISA, LLB, and is certified CSR professional and POSH trainer. Her expertise span taxation, corporate governance, appellate proceedings, and assurance services for listed companies and PSUs. She has worked with the leading Big Four firm and currently serves as a partner at Messrs. Khewani Sood and Associates. Her contribution to ICA committees and her leadership in professional circles reflect her commitment to excellence and advocacy for ethical governance. With that, I now hand over the session to our esteemed speaker, CA Nitika Kiwani Sood, to take us through the today's topic, Introduction to POSH Act 2013 and Professional Opportunities for CAs. Over to you, ma'am. Thank you.
Thank you, Amita ji, for the welcome address and for the generous introduction. And at the outset, I would like to express my gratitude to CA Abhay Chhajir ji and CA Pramod Jain ji for this opportunity and for the deep understanding of the law's significance and the urgency of the moment. Undoubtedly, in the past few months, the Act has caught fire and the penal consequences for non-compliance to the Act can be of serious concern. Thank you so much for this opportunity. Aparna ji, I would like to share my presentation and then we can take it in a Q&A form. Ma'am, as the POSH itself says, the Act itself says that it is Prevention, Prohibition and Redressal Act 2013. And it is mainly for the sexual harassment that occurs at workplace. So the first question that primarily comes is, why is it important for the professionals and CAs to be aware of the POSH Act? And how can chartered accountants play a role in ensuring POSH compliance for businesses? As you can see, that this domain is to a great extent is being explored by professionals who are, I would say, legal professionals and company secretaries. And the reasons are obvious. Any act which is litigative becomes the domain of a legal professional brothers and sisters. And as far as company secretaries are concerned, handling the secretarial compliances with respect to the reporting with MCA. Now, Mitaji, the question here is why us? Rather, I would like to say why not us? When CAs can decode acts like income tax, GST, then why can't we explore the professional opportunities with respect to POSH Act? We can be certified POSH consultants, and even if we do not wish to obtain this certification, we can still assist our clients in drafting of POSH policies, become an advisor to them, guide our clients on the compliance front, and also, I'm not sure how many of us know that is applicable to us also as a CA firm. And Amita ji, recently there was a MCA circular wherein it has been mandated the details pertaining to POSH compliance have to be a part of the board report, and that report is filed as an attachment while making the annual compliances on the MCA portal. And therefore, as a chartered accountant, I must be aware of the law and be able to guide my client accordingly. Then comes, why do we need a separate act for the safety of women when we have the police administration in place? Sorry,
It's not
repeat.
in that slide mode.
Yes, now I can do. Should I share just the PPT? Okay. Is this fine?
Yes, it's very fine.
And would you like to go ahead with the question?
Yeah, please proceed, ma'am.
So why was there a separate need for this act for safety of women when we have police administration in place? Amita ji, let me take you back in time. This will help me answer this question in a better way. In the year 1992, a social worker named Bhavri Devi, her work was to prevent child marriages. She prevented a child marriage of a 1 year old girl, and this prevention came with a lot of resentment from the society due to the villagemen of the village who got furious at her, and when she filed a complaint against those men with the local administration, those men in revenge gang raped her. As can be made out, Bhavri Devi was a woman and working for as a social worker. That is, it was her workplace. This rape was not taken lightly and was taken up by a social worker who filed a PIL before the Honorable Court of Rajasthan, which came out with guidelines known as Vishaka Guidelines in the year 1997. The guidelines laid down emphasis to consider the safety of women at workplace. In fact, till date, in government offices, if any of us are aware that they would generally not call POSH, rather they would generally quote it as Vishaka guidelines till date. But somehow the matter did not end here. In the year 2012, the country witnessed a grave gang rape, the Nirbhaya gang rape, which raised concern over women's safety across the country, and this led to the act which is now known as POSH, Prevention, Prohibition and Redressal Act 2013. This act laid the entire onus of women's safety at workplace on the shoulders of the employees. This act also This act also has a constitutional validity, and there are various articles provided by Indian Constitution which are covered under POSH Act, like Article 14, treating all people same in the eyes of law, forbidding discrimination on the grounds of religion, race, caste, sex, or place of birth, provides freedom to speak to every citizen to express their opinions without any fear, protection of life and personal liberty. What are the objectives of the Act? And how does sexual harassment impact an organization's work culture and productivity? Can we actually link it with the objective of the Act? As seen from the centuries, women are considered as a weaker gender. Physically, if I may put it so, and also seen as a caretaker. Homemaker, as in the older times, it was women who stayed back home, nursed their kids, their ailing parents, looked after the household chores, and men were the ones who would venture out of the homes to earn a living, which was supposed to be the prime responsibility given to the men, and they were the providers. And this biasness of women being weaker and men being some stronger somewhere still persists. The nature of biasness and degree could vary from person to person. And with the ongoing atrocities on women, it became important that as employers, we also take care of the safety of women in our offices. And so the onus of women's safety at workplace was casted on the employer. And needless to say that having a safe workplace fosters a culture of respect, trust, and inclusivity. A safe and supportive work environment will not only boost the employee morale but help in enhancing overall productivity. So, the objective of the Act is very clear. It provides the women with prevention, protection, and a redressal mechanism at workplace. As you can see that applicability, this act is applicable to the entire India, to all states of India, to all forms of organization, be it proprietorship, partnership, company, LLP, any form of organization, they are governed by this act. The Act segregates compliance in two parts. If an organization has less than 10 employees, they are considered as an unorganized sector and are exempted from having their own internal committee. Hence, dependent on the local committee formed by every district of the respective states as against an organization which has more than 10 employees has to form their own internal committee. And we shall discuss this in length once we proceed with further. Also, as you can see in this slide, that there is no such thing that if an organization does not have a female employee, this POSH Act will not apply to them. It is irrespective whether I have a female employee or I do not have a female employee. See, this act is applicable to all organization and nowhere it specifically mentions that an organization not having women employees would be exempt. And the reasons are, of course, obvious that the Act would not want to refrain the work opportunities for women. Also, since the Act is laying the onus on women's safety at workplace, it does not restrict itself to only women employees. It also includes women visitors visiting the organization for the purpose of work. For instance, you would see saleswomen visiting your office or the team of auditors. And as we go forward, we will be able to understand why in a better way. This act folds itself into five important definitions: sexual harassment, who is an employer, what is a workplace, who is an aggrieved person, and what are the forms of sexual harassment. Now, what exactly is sexual harassment? And often I'm also asked that would WhatsApp messages or email also be considered as sexual harassment? Why? And if not, then why not? But before I take up this question, I would first answer what exactly is sexual harassment. Sexual harassment includes any one or more of the following: it is an unwelcome act whether directly or by implication. It is a physical contact or advance. It is a demand for sexual favor. It is making sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non verbal sexual conduct of sexual nature. So I would further break it down into verbal or non-verbal. So, verbal sexual harassment is when somebody cracks offensive jokes, remarks, teases us, or is asking for sexually related questions. They are pestering for sexual advances, sexual favors. They might be inquiring about sexual preferences. They are gossiping, spreading rumors, body shaming, but with a sexual intent, making kissing sounds, whistling, sending mails, messages that have a sexual content, or even intimidating or threatening or blackmailing to have some kind of a sexual favor from the victim, and constantly asking out for dates. See, constantly asking out for dates and asking out for coffees, but with the nature of a sexual intent. So one has to really demarcate that what the intention was behind asking. And if a woman says no, we should actually consider it as a no and not as a rejection. Maybe it is not, we are not her preference. Let's not take this on our egos and take it on a revenge side, and then go for something like this where we start intimidating them. So a no in itself is a complete sentence, and I think we should respect somebody's preference for a no or yes. Then comes non-verbal. Of course, the name itself is very clear that it is not verbal. It is something which is physical, which is looking someone up and down, um, maybe having a physical contact like touching, pinching, brushing aside, trying to touch them while talking, blocking a person's path, giving them gifts which display a sexual suggestive gift. For instance, a colleague would gift his team member a set of lingerie. So there are things that indicate that the intention behind is there is a sexual content in it. Then making sexual gestures with hands, body movements, throwing kisses. And a new form of sexual harassment is also by cyber stalking someone, displaying sexist or offensive pictures, sending them MMS, WhatsApp, or emails. So these are also a different kind of a sexual assault that one would go through. And like you can see that there are certain instances of sexual harassment that I've displayed here on the screen. But even at times, once you speak to someone, so they'll say, "Oh, we were just joking," or "It was just a healthy flirtation." I think it's harmless. But to be honest, there is no such connotation as healthy flirtation. So one has to be very careful of the language they use with their peers, their colleagues, their juniors, with the women employee, with their team members. We are at work. We have to maintain a certain decorum. It is not our personal space and we have to respect it. And coming back to more instances, for instance, WhatsApp messages, like even sending kiss emojis, like you can see in the screen also that he's written "Good morning, dear" with the kiss emojis. So these emojis are also a way of expressing and can be taken otherwise. In fact, courts have now started considering emojis as a verbal message and as a medium of communication. So when we send these heart emojis, we should know to whom we are sending and why we are sending. We should avoid sending it to our team members, our employees, our juniors, our seniors. Again, I would say that we are at a workplace. In fact, recently there's a judgment where WhatsApp has also been considered as a workplace since the work communications are happening over WhatsApp. So, as an employer and as professionals, we need to be very careful of the way we conduct ourselves and guide our clients and guide our fellow colleagues not to cross the line. Often we are also asked, is there any difference between sexual harassment and sex discrimination? Aren't they both the same forms? Just because the word sex is coming in both the things doesn't mean that it is sexual harassment. Sexual harassment, we've already discussed that it is something which is unwelcome. It is a physical touch, having a sexual nature, the intention of a sexual nature, demanding sexual favors. Whereas sex discrimination is completely different. It is basis of the certain gender biases that we go through. For instance, I would say a manager may pass a comment to his female employee in anger that you females are just meant for household work and not fit for office work. So, this is a sex discrimination which has happened to me because of my gender. It is not sexual harassment. Or say there is a company recruiting people, and this lady who is newly married, even though fit for the role, is not considered because she is newly married, and the employer assumes that she may be on a family way soon. So these biases are sex discrimination and not sexual harassment. And therefore, if I may add, they are not governed by the POSH Act. And with this, I would like to conclude the workplace sexual harassment, as in what are the key elements. As we know, it is unwelcome, it is something that we do not appreciate. It has to be sexual in nature and it is subjective. By subjective, I mean that it is the impact that matters and not the intent. And also, we have seen that often occurs in a matrix of power. By this, I mean from senior to junior. So, what do I mean by impact? Okay, like I said, that the person said it was just a joke or it was just a healthy flirtation. Maybe it was a joke for him, but not for me. So, it is that what was the impact that came on me and not what his intention was. An impact could be something which could help harm me on a professional front or on the personal front. On professional front, it could be decreased work performance. I would like to stay absent and then there'll be loss of pay. I may lose my promotional opportunities. There may be retaliations. I may be subject to gossip, objectified, uh, publicly sexualized, and I will lose a lot of career opportunities. And on the personal front, it could be traumatic. Again, it depends on how I have been impacted. Everybody has their own set of emotions, everybody gets their own set of impact. I could go into depression, I could have anxiety, there could be fatigue, there could be eating disorders, and so on and so forth. So, again, this could be very serious. The intention doesn't matter here, but the impact on the victim matters here. Okay, so I think the one thing that always comes to our mind after hearing so much, that this is verbal, this is non-verbal. Verbally, if I say something, it may be taken against me. So, do you think that complimenting in an office should be barred? Well, I don't think so. If we know how to compliment, there is no embargo in giving compliments. For you should know how to compliment, your words should be appropriate. Let me take this example. Say in this first slide, it shows that he says, Smita, you look great in this outfit. And in the other one, he says that sometimes it becomes difficult to control. So there is a difference. There is a very thin line between the compliment and sexual harassment. He should have just stayed to this line, Smita, you look great in this outfit. I can take you more through more examples. For instance, a lady put a WhatsApp status in a yoga pose, to which her manager commented, "You do yoga? Wow, you are such a health freak, making your body so flexible. Your husband is a lucky man." So the manager should have known where to stop. He could have just stopped at, "You're just a health freak or you're doing something very nice for your body." He should not have gone way ahead. So we should know where we need to draw the line and when that compliment or that comment becomes a sexual harassment. Also, one thing I would like to add here, that for any workplace to function properly, it is very important for us as employers and professionals to follow the rules and regulations, whatever has been laid down in the act. Like we take care of other labor laws applicable to our clients, we should emphasize that our client is fully compliant with this act as well. Uh, Another question that came to me was, what if a manager scolds an employee or asks to work in a certain manner and employee may regard it as sexual harassment? See, if I'm asked to come to office and work from my office, it is my code of conduct. if my physical presence in the office does not mean that I'm being sexually harassed. So, if my manager or my senior is asking me to do a particular job as per code of conduct of the company, and the based and bases the instructions of my senior and does not have any sexual intention behind those instructions, then it is surely not considered as sexual harassment. For instance, follow up on absenteeism, work performance assessments, exercising of management rights and controls, conditions of week, constructive feedback. Often we get a feedback from our managers and we take it otherwise that, oh, I've been criticized, I've been demeaned, and maybe he's trying to threaten me. So, if it is work related and there is no sexual connotation behind it, let's not include this. Everything doesn't come under the guidelines of POSH. Everything is not sexual harassment. We need to know what is sexual harassment, what is code of conduct, what is sex discrimination. There are thin lines between everything. There is workplace harassment. There are thin lines behind everything. So we need to know what exactly is being governed by POSH. Every complaint should not be about sexual harassment. Like in the previous slide, I said that brushing aside, pushing, touching, maybe it was just an accident. Maybe he just walked past and by chance his hand touched me. It did not have any sexual connotation. So these behaviors, they do not constitute sexual harassment, and we should not force everything to come under this complaint box. We should know, we ourselves should also know that what is right and what is wrong. And see, revenge, sometimes people, have a relationship and eventually they break off. Then one fine day this female decides that, okay, I want to take revenge on this person, he dumped me, so I will file a case on POSH and I would take revenge from the person. Let's not use any act to take revenge. Let's use it ethically. And also for this, I would also like to add that, a lot of companies are now having a relationship disclosure policy. So in case tomorrow we have a case and we know that these people were under a relationship, so anything that happened between them within that period of the relationship was consensual. So while considering their case or their complaint, we will have to consider in those factors as well. Coming to another definition, who's an employer? An employer, as can be seen very clearly, that it is anybody who's heading the organization. For instance, workplace of government, local bodies, head office, officer specified, officer on special duty. In private workplace, person responsible for management, supervision, control. And then there is dwelling house, any person who is employed and the employer is being benefited from that employer. This is a very interesting aspect of dwelling house, which means that our own houses are also considered as workplace for the part-time workers, our domestic workers, as they are workplaces for those employees, and we as employers are deriving benefit out of it. So those part-time workers, domestic workers who are working in our houses, for them, our house becomes the workplace and we become their employer. So we need to be careful in our own houses also. They are workplaces for someone. Taking you through another definition, what is a workplace? A workplace could be a house, as we discussed. It could be an office, company, farm, nursing home, educational institutions, sport facilities, any service providers, manufacturers, corporations. So anywhere where any organization will be considered as a workplace. And recently there has been a judgment which I already mentioned that WhatsApp will also be now considered as a workplace. This concept of an extended workplace puts a lot of onus on the employer because where all can be controlled. See, we have extended workplace, which means, like I said, that a sales girl walking into our office, for her, our office becomes an extended workplace because she is here during the course of her employment for her work related matters. So for her, in case something happens to her or some kind of sexual harassment happens to her in my office, then for her there will be two internal committees where she can file a complaint. She can either file a complaint with my internal committee, or she can file a complaint in her own office workplace internal committee. But the another aspect of the extended workplace is very often we give shuttle services to our employees. So those shuttle services are also the extended workplace. We go to audit places, we have our office parties, we have our annual offsites where we take out employees. These are all covered as extended workplace. Even team dinners, team lunches, they are all extended workplace. And as an employer, it is a very big onus that has been cast upon our shoulders, because often there we have drinks in those parties and it becomes difficult for us to sometimes manage the employees at that hour. So we have to be careful what kind of parties we organize, and also ensure that women in those parties are safe. This is a case law which says that what factors should be considered while determining that this is a workplace. Of course, these are only few of the factors. It may differ from case to case, like proximity from the place of work, control of the management over such place, residence from where the woman is working, or if such a residence has to be extended and considered as a part of a workplace. So there are different factors which may differ from case to case, but yes, workplace or as workplace or not. As I mentioned earlier, that we've already discussed what is the difference between sexual harassment and sex discrimination. Then there is also a difference between sexual harassment and workplace harassment. So sexual harassment is already discussed that it is a gesture, it is an unwelcome act, it has a sexual nature, and it is handled by IC or LC. It is governed by POSH, where the victim necessarily has to be a woman. It is not a gender neutral act. And on the other hand, there is workplace harassment, which is non sexual. It could be bullying, taking undue advantage, discriminating someone on the basis of their gender. uh, it is those cases are generally handled by the HR or any grievance redressal committee that the company may have. And the rules are the rule governing those matters are the code of conduct of the workplace, and it is gender neutral. Anybody of any gender can register their complaint as far as workplace harassment is concerned. Who is an aggrieved person? An aggrieved person is necessarily a woman, or a person who portrays to be a woman. By this I mean there are transgenders or there are other genders who portray themselves and treat themselves as women. They will be considered and covered under this act. So an aggrieved woman is uh, anyone who's working for us, from whom we derive any kind of benefit, who's visiting our workplace. She could be a student, an apprentice, an article, a trainee, work for us with or without remuneration, directly, or has come through a contractor. It could be a regular worker, temporarily, ad hoc worker, domestic worker. So any woman who works for us or visits us for the purpose of work is will be considered as an aggrieved person as far as this act is concerned. Coming to what are the forms of workplace sexual harassment. This is divided into two categories: quid pro quo and hostile work environment. Quid pro quo, as the name suggests, this for that. If you do this for me, I will do that for you. It could be if I get a sexual favor, I may promote you, I may give you a good increment, or it could even be threatening someone. If you do not give me a sexual favor, I'm going to risk your employment. I can fire you, I can demean you, smear your character. So it is a this for that. Then comes hostile work environment. Hostile work environment is where I'm intimidated or the environment is offensive, but again, there has to be a sexual intention behind it. It is not that, my manager is abusive or talks badly to me, would be governed by POSH. No, that would be workplace harassment, not sexual harassment. I will take you through this through two examples and it'll become more clear. Kamini is a bright young team leader working in a call center, known to be dedicated, hardworking. Kamini stays at work late one evening with her colleague Ravi to complete work for an important presentation. Ravi offers to Kamini to buy her dinner and later drop her home since it's been a long day. After dinner, Ravi proposes to Kamini that he would like to spend the night with him. Kamini refuses politely but firmly and goes home. Next evening, Ravi repeats the same request and Kamini refuses. But with this, he threatens her that if she doesn't give in, he will tell everyone that she has made a pass at him. So, in this, what is the sexual harassment? In this example, Ravi is threatening Kamini that if she does not agree to his request, he will in return smear her character, that is, blackmailing her. Ravi's behavior is unwelcome, sexual, and has a negative impact on Kamini. And then comes a hostile work environment. As I mentioned, that it is an intimidating or offensive work environment which can be humiliating enough to affect the health or safety of a woman. She is generally objectified and it becomes difficult to work in such a workplace. For instance, Jayanti works in a garment factory in Bangalore. Verghese, Jayanti's supervisor, often tries to touch her on one or the other pretext. For example, he would adjust her dupatta while she is sewing at her workstation on the pretext of covering her back. Jayanti is uncomfortable with this behavior, and her colleagues at the workplace ridicule Jayanti and mock her for the special treatment by her supervisor. They often gossip about her and Verghese. So, in this example, the physical touching by Verghese is unwelcome and sexual in nature. The gossip, which is Verghese's behavior towards Jayanti at the workplace, is creating a hostile work environment for Jayanti. With this, we are clear of what are the kinds of sexual harassment at workplaces. Moving on to the complaints committee. This forms a very important aspect of the act. As I in the initial phase, I said that we are divided into two sectors. One is unorganized sector and one is the organized sector. An organized sector will have to have its own internal committee, and an unorganized sector will be dependent on local committee, which are formed by the district officers in each state. These are two kinds of complaint mechanism where you can approach them for redressal of your complaints. The 50% strength of this committee has to be women. The structure of the internal committee is, first of all, every employer in the organized sector is obliged to constitute an IC. An IC is composed of following members: the presiding officer, a woman working at senior level as an employee can be taken as the presiding officer. In case I do not have a senior women employee in my own administrative office, then if I have a sister concern or I workplace within the same employer, then I can also nominate a woman from that workplace as a presiding officer. Then there have to be two members minimum, we can have three as well, who have to be the employees of the organization. They should be sensitive to the women safety. They should have little legal knowledge and experience in social work. Then comes the external member. This external member is not anyone from the organization. It is someone from outside the organization. The intent of having an external member is to have that there's no bias while deciding the case. See, all the three employees could be influenced, but an external member who's coming from outside the organization, they have no vested interest in the organization. So they are there to see that everything is happen on a fair manner, and they are generally from the NGO or associations where who are working for the cause of child and women safety, and they're familiar with the sexual harassment cases. They have the experience to handle them, or they are having legal knowledge. The essentials to be considered while forming an internal committee is that in case we have different offices in different state, in different parts of India, then it is recommended that there will be an IC set up for every administrative unit. Every state shall have a separate IC. Not less than half of the IC members shall be women. Like I said there in the earlier slide, there were 4 members. We can even have 5 since someday one is absent while deciding a case. Or while deciding a case, there are 2 on one side and 2 on one side. So in case we have 5 members, there could be 3 on one side and 2 on one side to decide the matter. And maybe if someday someone resigns, so then we immediately don't have to fill in a position because we already have minimum 4 members in the quorum. The term of the IC member shall not exceed 3 years. A minimum of 3 members of the IC, including presiding officers, are to be present for conducting the inquiry. The IC member should be selected based on evaluation of various factors, including whether they are accessible, approachable, committed, sensitive, and understanding. They should be sensitive to issues pertaining to gender based violence and should have good credibility and technical competence to handle grievance procedures. Coming on to what is the structure of local committee. Here also we need 4 members, but this is a committee which I have not formed. This is a committee which is state driven, and it also has 4 members. As you can see that most of the members which have to be selected for this committee are the members who have their experience in dealing with social welfare of women and child development. They are working for the cause of women, their safety, and they have a background of law or legal knowledge. So all the 4 members would more or less have the same kind of a background, and one person will be nominated as the chairperson, who would be amongst the eminent members of as compared to the other members. And this this committee will be there in every district of the state. Also, while we file a complaint, there are 3 ways where we can file a complaint. One could be IC or LC. Second could be filing an FIR. And third could be filing the complaint on the SheBox portal. These days, it has become mandatory for us to register ourselves on the SheBox portal. So why this formation of IC or LC is mandatory? Of course, it is mandatory to prevent and to redress the complaints that a woman would have. It ensures that the place where women work are safe, there is redressal. It sends a clear mechanism that there is a designated committee with external expertise, and it prevents a series of litigation. The cost of not having an IC can be humongous at times. In case anybody goes out for complaint on the legal forum, then we come to know that there is no IC. This cost can be humongous for the organization. For instance, in this case, where Honorable Madras High Court awarded a compensation of 1.68 crores to an employee because there was no complaints committee by the employer as per Vishaka guidelines. So non-constitution costed a significant amount to the employer. So we must get our house in order in case it isn't. Moving on to what are the essential elements of a complaint and what should a complaint contain. So first and foremost, why am I filing a complaint? I'm filing a complaint because there was a conduct that was displayed on me was improper, was offensive, was sexual nature, and was done at the workplace. The behavior was directed at the complainant. The complainant experienced harm. The behavior occurred in the workplace or any location which was work related. What should my complaint contain? My complaint should contain a detailed description of the incident, the date, timing, respondent's name, and working relationship of the parties. Any other detail as far as witnesses can also be, their names can also be given at the time of filing of the complaint. And in case the complainant needs any assistance to file this complaint, then it is the role of the IC to help them assist in filing the complaint. Also, there is an informal mechanism by which we also call it as conciliation, by which we can resolve this issue. So, of course, you can give an informal complaint in case you don't want to follow the complete formal path of filing a complaint and going through the investigation. Process of conciliation is totally done at the initiation and at the request of the complainant. It cannot be that IC decides it suo moto that they would want to settle it by way of conciliation. It is a settlement between the complainant and the respondent. The complainant and respondent must agree to the terms of settlement. Only then it will be considered that the complaint has been resolved by way of conciliation. And if the complainant wants to move through the process of conciliation, then they have to express it so before the investigation starts. There are 6 stages for the complaint process, and I shall take you through them each one by one. Stage 1 is, of course, receipt of the complaint. Stage 2 is planning. Stage 3 is interviews. Stage 4 is reasoning. Stage 5 is finding and recommendation. Stage 6 is reporting. So once we receive the complaint, we need to receive it and acknowledge the receipt of the complaint. We have to sensitize the complainant that we have received the complaint and we shall look into it. We need to meet and talk to the complainant and explore whether they would want to address this complaint through formal resolution or an informal resolution. And then the respondent has to be informed and we have to wait for his response. We have to prepare the file, consider the facts of the case, interview the complainant, the witness, the respondent, assess that we have the complete record and which is now available is ready to be analyzed. During the course of inquiry, we have to create a timeline to establish the sequence of events, compare the similarities and differences within statements of made by the interviews, conclude the finding, give a recommendation, and then write the report. These are the 6 essential stages of going through the entire process of complaint. There are essential timelines that need to be adhered to. The complaint has to be submitted within 3 months of the last incident. So whenever I faced a sexual harassment, I have to file the complaint within 3 months of that incident. The notice to the respondent has to be given within 7 days of receiving the complaint copy. The inquiry in totality has to be completed within 90 days. The report by IC or LC has to be submitted within 10 days of completion of the inquiry to the employer or district officer, as the case may be. The recommendations given by the ICLC have to be executed by the employer or the district officer within 60 days of filing of the report. And in case any of the complainant or the respondent is not happy with the decision of the IC, then they have the right to move to appeal in an appropriate court. This has to be done within 90 days. Who all can complain? Of course, we know that the complainant can complain. But is there anyone else who can complain? As you know that the impact varies and the trauma varies. So it could be a possibility that the complainant is not physically fit to file a complaint or is mentally incapacitated. So in that case, the complainant's relative, complainant's friend, co-worker, special educator, officer, or any person who has the knowledge of the incident and with the written consent of the complainant can file the complaint. And in the most dire consequences, in case of complainant's death, then any person with knowledge of the incident with the written consent of legal heir can file a complaint. So it is not that, I told my friend about the incident and she felt more bad than I felt, or maybe I did not have the courage, but she was courageous, so she went and filed the complaint. No, I have to actually authorize her so that she can file the consent with the complaint with my consent and with my knowledge. So it is not that anybody can go and complain. It is either the complainant or there are certain set of people who can file the complaint on behalf of the complainant. Also, it is seen that there are questions that that come up, that whether a woman can complain against a woman, or a transgender be covered under this act. So yes, uh, people of same gender, that is two women, one can be the complainant and the other can be the respondent. And as far as transgenders are concerned, anybody who portrays or thinks himself to be a woman, then those transgenders shall also be governed by POSH Act, and they can file a complaint under POSH for any kind of sexual harassment that they may have gone through. This act also gives us some rights and duties to the complainant, and as a person of uh, belief, or I would say, to be true to someone, we should have know what our duties are by filing a complaint. We should be There is always an option to settle through conciliation. The complainant can ask for interim measures during inquiry proceedings. Interim measures could be that she is not happy coming to the workplace, so she can take work from home, or she can take leave for a few days. They can ask for assistance for filing police complaint, or deserve an empathetic hearing. Be honest about the complaint. This is an essence. We should be always honest about the complaint. It should not be a false or fake complaint. As I said, that we should not do it out of revenge. Appear before the ICLC as and when required. Produce documents and witness, if any, and cooperate with ICLC proceedings whenever and as and when required. Often there are cases that go unreported because of the fear of retaliation. So, yes, there could be a fear of retaliation, and people could feel that, if I complain, then something is going to be taken against me, or the respondent is going to take vengeance in some form or the other. So, ideally, it is not only the duty of IC or LC to take care that employee does not face any retaliation by the respondent or by his known peers or family members, whether it be during the investigation or after the investigation, or after the IC has given their findings or recommendation. It is also the duty of the organization to form such policies where retaliation is treated as a misconduct and shall be subject to penal actions against the respondent if there is any kind of retaliation, or there is any suspicion that a retaliation may occur. What are the finding and recommendations by the committee? See, if a person is found guilty, the committee will always uphold the matter. But even if the committee is not able to uphold the complaint or recommend no action, then also the committee should specify and mention it in their report. The recommendation or action to be taken against the respondent could be either as per service rules of the organization, and it can be same is then the recommendation can be considered as disciplinary action, apology letter, reprimanding, withholding of pay, holding on the promotions, counseling sessions, community services. The act in itself refrains from giving any kind of financial damages. That is not recommended. But in case of special circumstances or the trauma or impact on the complainant, there may be circumstances when the IC feel that there should be some financial damages that the respondent should pay. But at the same time, the IC should also consider the financial capacity of the respondent and provide a recommendation accordingly. First of all, let's not go towards financial damages and make it a case where women feel that okay, we are going to have some kind of a monetary benefit out of it. So the act totally refrains the financial damage part of it. What if the complaint filed is frivolous or fake? Any false complaint is a punishable offense, and punishment can be those as per service rules of the company. And in case there are no such rules, then the complainant shall be subjected to disciplinary action. Disciplinary actions can be same as the recommendations that we've already discussed. It could be a written apology, a warning, reprimanding, withholding of promotion, pay rise, terminating the respondent from the service, depending on the case to case and the factors that we are considering while deciding the recommendation. These are the details that an organization must file in a POSH compliance annual report. A POSH annual report has to be filed on an annual basis. It follows the calendar year, not the financial year. This report has to be forwarded to the district officer within 30 days from the closure of the calendar year. In some states, the states give us an extension also. Like this year, there was an extension for the state of Haryana. So they were supposed to file the report by 28th of February instead of 30th of January. The very basics that form the part of the report are number of the complaints received, number of complaints disposed of, number of cases pending for more than 90 days, number of workshops, awareness programs carried out, and nature of action taken by employer or district officer. The next aspect is which interest all of us as chartered accountant. It is penalties. It is something that we really want to know for any non-compliance. So as you can see that the penalty is 50,000 for per non per contravention of the act, failure to constitute an internal committee, failure to act upon recommendation of the complaints committee, failure to file an annual report, contravening any other act or rules of the provision. And then, if the employer repeats this breach, the punishment will be twice the punishment or the higher or maybe higher as may be prescribed under the law for the same offense. It could also lead to cancellation and withdrawal or non renewal of registration license required for carrying on business or activities. So, the penal consequences can be really serious, and we need to comply with this. We need to tell our clients that they need to comply with this, or else, if there's recently on 12th August, there's a Supreme Court uh, direction that all the states have to within 6 weeks file that wherever the organizations are not complying with the POSH Act. So I think the time is really running out. In case we are not complying it, we should start as soon as possible. The act is, of course, the whatever we've discussed is a very sensitive issue. Anybody who goes through it is the one who actually realizes the impact of it. So one needs to be very confidential of the entire proceeding. The IC has to maintain confidentiality, and this is not only that IC or LC has to maintain this confidentiality. It is also the people such as witnesses, they have to maintain confidentiality. In case any of the information travels outside, then there is a fine that of rupees 5,000 or any other rules that may be governed by the organization may have, and this amount has to be collected by the employer. Only exception to this is that if anybody goes into appeal or for the sake of justice, that there is a requirement for the organization to disseminate this information, then they can do so subject to certain terms and conditions. Discussing this case law, Mrs. Arvinder Bagga versus Local Complaints Committee. In this, Medanta Hospital was slapped a penalty of 50,000 because it did not have an internal complaint committee. And for this, the complainant was compensated an award of 25 lakh rupees because there was no committee to address her complaint of sexual harassment. Recently, there has also been an imposition of penalty by ROC Karnataka, which imposes a penalty of 4.5 lakh rupees on the company and its director for non-compliance of not disclosing the compliance of POSH in the Director's Report under Section 134 of the Companies Act 2013. See, the Section 134 of the Companies Act is actually imposes penalty for general non-compliance, where in a company can be levied a penalty of 3 lakh rupees, and every officer in default, including directors, penalty of 50,000 each can be imposed. And for Section 448 of the Companies Act, it imposes penalty for false statement or misrepresentation. So if a person who makes a false statement in the board's report, knowingly or unknowingly, without belief in its truth, is punishable under Section 447, which is for fraud. And now that MC has made it mandatory to be a part of the board report, we as CAs need to guide our clients to make good of the compliances. By this, I would conclude this session by stating that there are certain good practices that even we or our clients must follow. That policy should be effectively communicated to all the workers. It should be displayed, and the IC details should be displayed at a conspicuous place where everybody knows who my IC members are, how they can be contacted, how I can file a complaint. We should regularly conduct orientation on workplace sexual harassment for all our workers in the organization. And our complaint committee should be trained. Our senior person leaders should become role models in not only preventing sexual harassment but also ensuring that there is no workplace harassment or there is no sex discrimination. And men and women should together be included in building a culture which no longer tolerates workplace sexual harassment. With this, we are open for Q&A if there's any.
Yes, there are certain questions coming up. I'll read the question.
Sure, ma'am.
It's from Vivek Srivastav. How to register IC members in SheBox?
Ma'am, you can log into the SheBox portal. It will ask you to fill in the login details. You will first have to create a login ID. And once you create a login ID, the major registration or the major details that the SheBox portal requires is of the organization and of the IC members. Only once the IC members are listed on the SheBox portal can it be made available to our employees in case they want to file the complaint on the SheBox portal. And once you log into it, then once you submit all the IC details, it gives the OTP on the presiding officer's mobile number or email ID. So it's not a very tedious process. Sometimes, yeah, the portal doesn't function properly, but otherwise it's going good.
Okay. The next question is from A. Sandeep. He says, is sexual harassment applicable only for female? What about female doing it male? Also, what are the cases where there is a female misuses POSH? What it is remedied to male?
Ma'am, as I said that this act is not gender neutral. A lot of organizations are making policies which are gender neutral in nature, but the act doesn't govern them. I can have two policies, one of POSH and one of code of conduct. So if a male member goes through any kind of harassment, they can file their complaint in the as far as the code of conduct is concerned. Maybe the IC would like to address it, but they can't recommend it as per the POSH. It will not be taken as a civil proceedings like it is taken for POSH Act. So of course the IC can entertain if the organization wants to, and also there is a general trend, that people say ki, a male never feels harassed, he rather enjoys. So I don't agree with this. So of course we've all watched movie Etras. So Akshay Kumar did have a problem when he was being harassed. So male also have problem. So they should be open. I think it depends on organization to organization how safe we make our employees feel and how open we are to take their complaints. And I have already discussed in my slide that if there is a fake or frivolous complaint, so again, it's part of the organization that they should have their service rules in place that if they come to know that this complaint was fake or frivolous, then the action should be taken against the complainant. And another point that needs to be taken care of, that in case I am not able to find that, I don't have a conclusive evidence for the complaint. That also does not itself make it to be a frivolous or a fake complaint.
Yeah, the next question is from Nishan. Condition that IC member should not exceed period of 3 years applies to in-house company employees also. It
Yes.
means all members are to be replaced. Can an ex-IC member rejoin the IC committee?
Yes, we can make the ex-IC member rejoin the committee by passing a board resolution. So the act says that it is recommendatory that we change the member in 3 years, but we can again renew their term for another 3 years.
Yeah, we are waiting for more questions. Please do write your questions. We'll address the more questions. Yeah, and there some course or organizations who provide this training for being a POSH trainer? This
Yes,
question
ma'am,
is
there are a lot of certification courses available. Even if they Google, they'll come to know of a lot of places where these certified courses are there. I did from ProTouch. So it's a good place where they can do this. And even if we don't want to be a certified POSH trainer, at least it gives us a detailed awareness of what the entire act is. Maybe I can use it for my own organization if I don't want to do it for the clients. But a word of wisdom I would definitely like to put here is that we should not use it to take revenge. It
yeah,
can, if it is going to harm someone else, it can harm us also.
some more questions are coming up. Jasmeet Dhawan has asked, what if 90 days has passed by? Can we still go ahead with it or would tell the complainant to do so again?
If the 90 days, it's a 3 month period. 90 days is that 90 days I have to finish the inquiry proceedings. Sometimes, in some cases, the 3 month can period can be extended to a period of another 3 months, but it depends on case to case. As per the act, it is 3 months from the last incident. Uh, there is also suggestions that are going on that this period may be increased to 1 year, but as of now, it is only restricted to 3 months. But in certain cases, we may be able to extend it to a period of another 3 months. And also for proceedings, if due to certain factors that witnesses were not available or something else happened, something else propped up, then we can extend that period also for few more days.
Uh, Again, some more question. Any ICI recommendation for certification course? Like ICI certification course is there for it.
ICI is not certifying this course yet.
Yeah. And one more question from Nishan. Is the she box mandatory to all corporate?
Yes, Shebok is now mandatory to everyone. I think a month or 2 months back, there was this direction that has come that all the states, the directions came for different states at different point in time. So now it's applicable to all the state. Earlier, it was applicable only to Uttar Pradesh. They were doing it for Shebok since past quite a few years now, but now it is almost mandatory to all the states that they have to register their organizations on the Shebox portal. They have to actually tell them who the IC members are.
One more question. Who can be the external committee member? Is somebody from any expert area of this legal sphere or anybody could be?
Anybody from the legal front can be an external member. A social worker working for the child and women safety can be a external member. A worker, anybody from the NGO can be there. People like us who have taken these courses and are certified POSH trainer can be external members. So we have to have some knowledge where we can tell that yes, we are able to handle these cases.
Okay, one more question coming up. It's from Rahul Kumar. What action can be taken if the person harasser is in a senior or managerial position? Like
See,
the
action can be taken same that we have to approach our IC. So the IC, that is why the entire intention of having an external member is that whatever the decision is, it is free from biasness. The people who there are employees also in the IC. So we see that if an external member is present, so the judgment that is carried out is fair because the external member has actually no vested interest. Also, as an external member and as a POSH consultant, we often advise that the members who are heading the IC should not be directors or partners of the organization because then their decisions would be biased to the reputation of the organization rather than actually solving the issue for the respondent or the complainant.
Another question popping up. As an audit point, do we check policies, IC committee, and return filing under POSH? What else the auditor or CA can cover in this?
Yes, as an auditor, you should check whether the company has their policy, POSH policy, like you check the CSR policies, likewise you check the POSH policy, whether the IC meetings have been set up, any complaints that were received. Because if there are any complaints received, like I said, that there's a non-compliance, there have been cases where the IC wasn't set up, the company had to compensate, or there was a penalty that was slapped on the company. So these are all financial implications which boil down to our financial statements also. And we as auditors anyways look into the litigations that the company is going through. What is the liability that is going to be cast upon the company in case anything comes through? So yes, we are bound to look into it. We look into ASIPF, we look into gratuity, we look into bonus. Then POSH is also kind of the similar lines that we need to look into.
Yeah, one more question regarding external member, that is it necessary to have EC in the IC committee?
Yes, it is mandatory to have an external member.
Okay, so questions are there. We refresh it. Uh, so the question is POSH committee required even if there are no female employees in an organization, have only contract female employees or no female employees in an organization, still POSH is required or not?
It says whether I have 10 employees or I don't have 10 employees. If I have more than 10 employees, I have to have my IC, which means that the presiding officer has to be a women employee. If I do not have a women employee, please employ one. If there is a women employee of the same stature in any of your sister concern or any other administrative unit, you can consider her as a presiding officer. But if you do not have a women employee, you need to have a women employee or be dependent on LC. Because if somebody who's gone through harassment and doesn't come to you to complain, then this complaint which stays internally in your organization will of course go into the public domain. Then she will either go file an FIR or she will report on the SheBox portal. So once it goes in the public domain, then your organization reputation and everything comes at a stake. So it is better to make this IC within your organization so that there is you comply with the provisions also, and then employees of your organization feel safe and they know that there is a redressal mechanism within the company that is available to us.
Yes, some more question is there regarding SheBox, that how, as an auditor, or we get to know that the company is registered out there on that portal.
You can ask your, when you go for an audit, you can ask the person concerned to show you the login on the SheBox portal. It hardly takes a minute.
We check more questions. There, there. What, there's a question again. What happens if the accused refuse to cooperate with IC?
If the accused refuses to cooperate with the IC, then IC can give their recommendations accordingly. If they are not, then that means that the complainant is right. There is something that the respondent has there to hide, and if he's not cooperating, they can terminate his services, reprimand him.
Question, if a company has 3 plants at different locations, does each plant should be having one separate IC, or only one IC committee can be made at corporate level? I think it's
See,
organization to organization.
yeah, see, the purpose of IC is that I have to have some mechanism where I can go and complain. The people, the IC is approachable, is accessible, and I know that they are there. So in case you have a corporate level policy, fine, but your IC members have to be approachable. If there's a complaint, then they need to be available there to listen to the complainant, to listen to the respondent, to conduct their inquiries. So it is only a logistical convenience that they have given, that that you should have an IC at every place, so that uh, the IC members are accessible to the complaint. And if the company is a big enough company, then I don't see there's any harm that we have any problems in setting up different committees in different states.
Maybe fresh if more questions coming up, or we can wind it up. One more question is there. What if even after having such committees, somebody goes to social media and report the matter? Do we need to take up the matter to IC on suo motu basis?
No, we don't have to take it suo basis. If they have gone on the public domain, if they have not come to me, then they will take it up accordingly. Only if they have come to me, then IC is going to take it. The complaint has to be filed with me.
Till now, these are the only set of questions. So I think we have covered majorly many questions out here. It was very interactive one, very knowledgeable even. If any questions are there, you may write to us.
Yes, they can write to us. I'll share my email ID also.
Actually, it's coming up here if to the question box panel also. So
Okay.
just asking them if they can write it. Yeah, you can share that. There are no further questions. So if you permit, we can conclude it, ma'am.
Yes, ma'am, we can.
Okay, so let me have a privilege to give a note of thanks to you. On behalf of CCLE and NPO Committee of ICI, I extend our heartfelt gratitude to CA Nitika Kiwani Sood for her insightful and comprehensive session on the POSH Act 2013. Your clarity in explaining the legal framework, practical illustrations, and deep understanding on the subject have truly enriched our knowledge and perspective. Your expertise in corporate governance and your commitment for fostering safe and inclusive workplace came through powerfully today. We are grateful for the time and effort you invested in making the session both informative and engaging. Thank you once again for your sharing your wisdom with us and for contributing meaningfully to our professional development. Thank you, ma'am.
Thank you so much, Amita. Thank you.
Yes,